Welcome back to PrepSolution's SHRM Senior Certified Professional Question of the Day. Today, we work a workplace domain question on U.S. employment law, where 3 of the 4 options are legally impossible. Cluster, workplace, competency, U.S. employment law, difficulty, hard. Here's the refrain. 2 systems, 1 law. Here is the scenario. You are tasked with standardizing a corporate dispute resolution process to reduce employment litigation. A recently renewed collective bargaining agreement mandates a specific multi-step grievance process for production staff. Which strategy is the most viable approach for the organization? Your 4 options. Option A, imposing a universal mandatory arbitration policy for all employment disputes. Option B, implementing a company-wide open-door policy that replaces existing dispute resolution methods to ensure consistent treatment. Option C, instituting a bifurcated framework that uses alternative dispute resolution for non-union employees while preserving the union grievance procedures. Option D, mandating a standardized peer review panel to adjudicate all internal workplace conflicts prior to formal legal escalation. Pause here, pick your answer. Ready? 3 answers assume corporate policy can cover everyone. Federal labor law says otherwise. The correct answer is option C. Institute a bifurcated framework that uses alternative dispute resolution for non-union employees while preserving the union grievance procedures. Why? Because the CBA is a contract, not a policy. The National Labor Relations Act makes it legally binding for the employees it covers. An employer cannot unilaterally modify, replace, or supersede its terms during the contract period. Corporate authority ends where the CBA begins. The SCP move is to standardize aggressively within the zone you actually control and respect the zone you don't. That's why option C is correct. Picture the workforce as a map. 2 territories, 1 legal boundary between them. The left territory, union employees, production staff covered by the active collective bargaining agreement. Their dispute resolution system is already defined, a multi-step grievance procedure that was negotiated, signed, and recently renewed. This procedure is not a policy the employer wrote. It is a contract the employer signed. The right territory, non-union employees, salaried staff not covered by the CBA. Their dispute resolution is governed by corporate policy, which the employer can design, standardize, and modify at any time. Between the 2 territories, a boundary. The National Labor Relations Act, Section 8 of 5, the law says corporate policy cannot cross this boundary. A unilateral modification of CBA-covered terms is an unfair labor practice. Full stop. 3 of the 4 options in this question try to cross the boundary. Option A imposes universal arbitration. The arrow crosses the line, hits the CBA, bounces back with a ULP on it. Option B replaces the grievance procedure with an open door policy. Same boundary, same bounce, same ULP. Option D mandates a peer review panel before any other process. The sequence change violates what the CBA prescribes. Another ULP. Option C is the only approach that respects the legal geography. 2 parallel systems, union procedure preserved exactly as negotiated. Non-union procedure standardized aggressively through ADR. Both tracks reach the same destination. Reduce litigation risk. Only one crosses the law. There is a second layer, the hierarchy behind the boundary. Federal labor law is a 3-tier structure. At the apex, the NLRA, set by Congress, cannot be overridden. In the middle, active CBAs set through collective bargaining cannot be overridden by corporate policy for covered employees. At the base, corporate policy set by the employer governs everything not preempted above. Each tier preempts the tier below within its scope. This is why options A, B, and D fail. All 3 try to apply base tier policy inside the middle tier's protected zone. Option C is the only answer that respects all 3 tiers. 4 moves to build the bifurcated framework correctly. Move 1. Identify the CBA scope. Map exactly which employee populations are CBA protected. Production staff, per the scenario. Document the specific CBA clauses on dispute resolution. These are immovable, until renegotiation. Move 2. Preserve the union procedure. The multi-step grievance process stays exactly as negotiated. No modifications, no parallel shortcuts, no corporate overlays. Attempting to change it during the CBA term is an unfair labor practice. Move 3. Design a DR for the rest. Build a standardized alternative dispute resolution framework for non-union employees, mediation, arbitration, or combined. Standardize within this population as aggressively as desired. Policy governs here. Move 4. Document the legal architecture. Write the policy so the bifurcation is explicit. Which procedure applies to whom? Triggered by what employment status? Legal counsel reviews. Plaintiff attorneys will test the boundary. Documentation is your defense. 2 systems work. 1 system litigates. Now, why the other 3 fail? Option A, universal mandatory arbitration for all employment disputes. A universal arbitration policy applied to CBA-covered production staff attempts to unilaterally modify negotiated dispute terms. An active CBA prevents this. The employer cannot change terms without bargaining. Section 8, A5 ULP on day 1. Unilateral modification, cross the line. Option B, company-wide open-door policy, replacing existing methods. An open-door policy is an internal corporate mechanism applied company-wide so that it replaces existing methods. It replaces the negotiated grievance procedure for production staff. The CBA's procedure is legally protected. Corporate policy cannot supersede it. Replacement of negotiated terms. Cross the line. Option D, standardized peer review panel for all internal conflicts. A peer review panel inserted as the universal first step mandates a process before the CBA mandated one. The CBA specifies what happens first. Any corporate step inserted ahead of it violates the sequence the CBA prescribes. Sequence is also a bargained term. Sequence violation, cross the line. The pattern. In any labor law question involving an active CBA, ask whether the option respects the CBA's scope, procedures, and sequence, or whether it imposes corporate policy inside the CBA's protected zone. Only respect qualifies. That is question number 8. If you want to pass SHRM-SCP the first time, PrepSolution has you covered. 1,500 strategic questions across all 3 domains, 3 full-length mock exams, 600 high-density review flashcards, the SJI Strategic Decision Masterclass, an adaptive 12-week study calendar. Thanks for watching. Practice every day. Pass with confidence. PrepSolution.com/exam/SHRM-SCP.